Welcome to the Emerging Litigation Podcast, a co-production of HB Litigation and Critical Legal Content, custom content for law firms and litigation service providers, and the newly formed VLEX Fast Case, your world of legal intelligence, and our friends at Law Street Media. I'm your host, Tom Hagee, litigation content producer, an enthusiast, and an average bongo player. Contact me if you have an idea for an episode. In addition to often being polite, I'm always looking for new twists on the law, whether it's a new regulation, legislation, or an important new opinion. Or it could be a development in the world that will test existing law, or anything you're dying to share with other litigators, organizations, or individuals. And if you like what you hear, give us a rating. That always helps. And now, here's today's episode. Non-compete agreements. You've heard of them. Employers like them because they help protect often invaluable trade secrets and other intellectual property, stuff they've shared with employees and some of which employees themselves help develop. They also argue banning these agreements will hurt their ability to compete. Employees argue these agreements hurt their ability to compete too, for higher wages. Proponents of the ban say non-competes stifle worker mobility and opportunities. Non-compete agreements can be used to block unionization, a right afforded workers by the National Labor Relations Act, critics say. 4 states have banned them: California, Minnesota, North Dakota, and Oklahoma. New York's governor has a bill on her desk. She's reportedly favored the concept in the past. The state's employers say it's too broad, and they've been pretty vocal about that. So we'll see. Other states have put limits on non-competes, such as not allowing them for low-wage jobs. Of course, even the definition of low-wage jobs varies. The FTC has proposed a ban on non-competes for all workers, including independent contractors. The proposal would also require employers to void existing non-compete agreements. The commission tossed the draft rule out to the world for comment in January, and it received 27,000 comments. It's a big deal, man. Banning most non-competes would impact about 30 million Americans. That's a lot of Americans. The FTC estimates the rule would lift wages by $300 billion per year. That's a lot of billions. The commission is not expected to vote on the proposed rule, however, until 2024. There's some other stuff going on next year. Not sure what those things are. If enacted, you have to ask, will the language of the rule be changed in light of all those comments? Will it be challenged after the fact? Of course it will. If it goes live, can we expect litigation as employers and employees fight over how to interpret the language of the rule? We can only hope. I did not say that, but that's about all I know about the situation. So listen to my interview with Andreya DiMarco, an attorney with the Hatfield Schwartz Law Group. Andreya focuses her practice on employment law and transactional matters. She's well-versed in the New Jersey Law Against Discrimination, the New Jersey Civil Rights Act, and the Conscientious Employee Protection Act. She's defended clients in federal court, state court, and before administrative agencies like the EEOC and the DCR. She's also handled intellectual property matters, so that's relevant. Andreya received her JD from NYU School of Law. Hatfield Schwartz is a woman-owned and operated firm, by the way, and its founders, Stephanie Schwartz and Catherine Hatfield, are on the editorial board of advisors for the Journal on Emerging Issues in Litigation. Tom Hagee, editor-in-chief. With that, here is my interview with Andreya DiMarco with Hatfield Schwartz. Hope you enjoy it. Andreya DiMarco, thank you very much for speaking with me today.
Thank you for having me today, Tom.
So let's set the stage for our listeners. We're talking about non-competes and what the government might be doing about them. So why do employers favor non-competes, other than maybe the obvious, and why have they become controversial?
There's several reasons why employers favor non-competes, and yes, as you said, the obvious, and the key being protection. So non-competes prohibit employees from jumping ship or leaving work to go work for a competing business or to start a competing business, and usually that's for a certain period of time or within a certain geographic location, but not always. It depends on the state, depends on the contract, the non-compete. But as a result, it allows employers to retain these key employees and to operate without fear, or at least with a decreased fear that these employees are going to be poached by competitors. And significantly, to me, the biggest argument for maintaining the ability to use non-competes is that it allows the company to operate without fear that these employees are going to disclose the employer's trade secrets or their IP or confidential information to competing businesses, or to use that information to open up their own competing business. So in this regard, it allows employees also to have more accessibility to confidential information, which arguably allows them to perform better. We can discuss this further, but I'll touch upon that the proposed FTC rule is not banning non-disclosure agreements outright. So it's not going to prohibit employees, or it's not going to allow employees to take their trade secrets and confidential information elsewhere. However, while that's great in theory, it's not so great in practice. So when you think about it practically, if an employee has this institutional knowledge, if they are a C-suite or upper level employee who has worked for this company for many years, they know the employee's strengths, they know the employee's weaknesses, they know the employee's clients, they have access to confidential information. They're only human, and once they leave the business, the employee can no longer control what that employee is doing. They can't monitor the conversations they are having. They can't monitor what they are doing. So how do you control that an employee is not taking your trade secrets, or they're not taking other confidential information with you? And that doesn't just apply to your C-suite employees. It can apply to all employees. And I'll use the example of DW40 because I was reading about this. So DW40 got the name because it took 40 tries or 40 different formulas to get it right. So if you take the scientists or the employees who worked on that formula, let's say they worked on formula 20 through 38, and now they leave the company and they go somewhere else. And this competing company or this other company says, we want to also create a lubricant. Even if those scientists or those employees have an NDA or some sort of restrictive covenant agreement that prohibits them from taking the DW formula with them, they already have that knowledge inside their head. So how can they really try to make this lubricant, this new product, without using the knowledge they already know and they already have? Granted, if it gets to that stage, there's probably going to be litigation and maybe this product would not be able to go forward. But it's just the point that in theory, NDAs are great. In theory, these agreements are great. But once somebody has that knowledge, it's already in their head. They can't unlearn it if they leave the company.
That makes sense. So what's the controversy now? I mean, to be clear, you're representing employers. Why have these become controversial? And I suppose that's coming from the employee side.
Right. So from the employee side, the controversy or the other argument is snowballing off of what I was just saying. So then you put somebody in a position where, okay, so is this C-suite employee or is this scientist, this other employee never going to be able to work anywhere again within this industry? And is that prohibiting someone from having that worker mobility or from making a living in the industry that they have chosen? And what we are seeing, what the Biden administration at least is focusing on, and what the FTC seems to be focusing on, is the lower level earning employees. So it impedes worker mobility. It prevents them from being able to work for the employer that they would like to work for or choose to work for. It is impeding wages, and that you're putting an employee in a position where now they have no bargaining power, or they can't go and accept a position with another employer who's going to offer them a higher compensation or better benefits.
So are they more prevalent in some? Now, we talked about different levels of an organization. Are they more prevalent in some industries than others?
They are. I think they are. There has been a lot of discussion since the FTC rule has come out around the healthcare industry, and that there are many physicians who are subject to them. And there's a lot of arguments on both sides of that as to the harm that is causing. And again, the reasons for maintaining those non-competes. But in the healthcare space, you're now looking at the harm to the public. So if you are prohibiting a physician from being able to go and work for a center or an area in the state where maybe there is a lack of physicians with a specialty, you're harming the public because people need access to healthcare. And it could quite literally be a situation of life or death if this physician cannot go and move into a center or to an area of the state where he or she may be needed. So that is certainly an area where we see them a lot. We also see them used a lot in cosmetology, so hair salons or barbershops, and in hospitality.
How do the states differ in how they treat non-competes?
So they vary widely. So some states have banned them entirely. For example, California banned them entirely years ago, although I should say that California also has the highest amount of trade secret litigation. So that's kind of an example of how you see how a non-compete can be offset or what the impact of not permitting non-competes is. Some states will ban them with certain exceptions. Some states will permit them, but with certain restrictions. So for example, in New Jersey, they are generally permitted. However, they have to be reasonable within their scope, meaning that the amount of time that they are in place for and the geographical breadth or scope has to be reasonable. And usually courts interpret that depending, again, on the facts, the industry, the specific legitimate business purpose that are trying to be protected. Usually the scope will be 50 to 100 miles and 1 to 3 years is what would be considered reasonable. Some states also prohibit them in certain industries. So again, I'll use New Jersey as an example. Psychologists cannot have non-compete agreements. And the reason behind that is they think that, again, the public person should be able to choose their therapist or their psychologist freely and move with their therapist and their psychologist. That same reasoning applies to attorneys. So they're banned. Attorneys cannot have non-compete or non-solicitation agreements. Some states will also limit them so that they can't be used for employees or workers who earn less than X amount of money. And personally, I think that's where I think the FTC rule will be going or should be going, but we'll see how that unfolds. And then there's also blue pencil states. So again, I'll go back to New Jersey. New Jersey is a blue pencil state, meaning that if a non-compete is litigated, the court can come in and modify it rather than holding that the non-compete or the restrictive covenant is entirely unenforceable. It will say, okay, we're going to modify it and change the 3-year term to 1 year and change the 100 miles to 25 miles. And this is how it's going to be put in place instead.
Yeah, at this point, I'm tempted to ask you a question about a personal non-compete issue I had, but that would be wrong.
We can talk off the record, off the podcast.
No. The beauty of being a lawyer, you must get that. My father-in-law was a psychologist, and he stopped telling people that that's what he was. I think after a while, he just said he sold insurance, and then people left him.
It's true. Sometimes I don't say it because exactly everyone wants free legal advice.
Well, that's why I do these podcasts. I just do them on issues that I'm having, and then I get free advice. No, this one was resolved. Okay, so let's talk about the FTC proposed rule. What can you tell us about it? Why now have they come up with this?
So in its simplest form, it's going to, if it moves forward as written, it will require employers to rescind any existing non-compete agreements for their current employees as well as any former employees. And it will ban non-compete agreements outright moving forward, which means they can no longer be used by any employer, or well, I shouldn't say any employer, there are certain exceptions, but most employers in every single state across the country. So, and why now? I think now because it's probably something that's been a bit controversial for years, but Biden came into office and the Biden administration has spoken about it a lot, and they issued a statement about it in 2021. And I think we know Biden spoke about it at his last union address. And now it's sort of like he's given the green light for the FTC to move forward and put it in the spotlight and propose this rule.
Say a little bit more about who's covered and who's not. You mentioned some exceptions.
So again, it bans it outright. It's going to apply to all employers that would be subject to the FTC Act. So the only exceptions there are nonprofit organizations, certain banks or financial institutions, and I think there is one more exception. Federal credit unions also do not have to comply with the act, but otherwise it's going to apply to all employers, and the same with workers. It does not make any exceptions for any specific industry or for workers who earn more than X amount or less than X amount, nor for independent contractors. So for all workers across the board.
Okay. So you talked about the state laws. So how would this interact with those?
So it'll supersede them outright. Like any federal law, it's going to supersede any state law. So that doesn't prohibit a state from having a more restrictive law in place. So they could ban non-competes outright and then also decide that they want to ban non-solicitation agreements. But it'll supersede all state laws. So now no state will be able to have enforceable non-competes in place.
And so I think the answer to the next one's obvious. What the rule will mean for employers and other entities. It means they can't have them. They have to eliminate ones that are in place. And right, that's it.
Exactly. What we've been speaking to our clients about is let's not get ahead of the game. Let's see how this unfolds before we start working on it. But just things to start keeping in mind are And you want to consider that if this goes into place as written, what do you need to change within your operations? So if you have right now that you allow several employees to access confidential information that you may not want them to otherwise have access to, if you can no longer be protected by these non-competes, how do you want to restructure your business? How do you want to restructure your operations? Do you now want to change it so that you only have a limited number of employees that are going to be able to access this confidential information moving forward? Do you want to put tangible measures in place? So do you want to physically move your files that may contain this proprietary information or trade secrets or other confidential information? Same with electronic files. Maybe you want to put more security measures into place so that employees don't have as easy access as they otherwise would have had. And then you want to start thinking about what other agreements can we put in place? So the FTC rule also has language in there as it's written now that not only will non-compete be banned, but any de facto non-compete agreement will be banned, meaning that if you have a NDA that also has language in there that can be construed as a non-compete or having the effect of a non-compete, the same with any confidentiality agreement, that those will be banned, whether they'll be banned outright or they'll just be the clause that will be banned. Those will no longer be permissible either. So I'm going to say for most of our clients, because this has never been an issue, we have restrictive covenants. We usually use them pretty broadly, where it'll have non-compete language, non-solicitation language, and confidentiality language all in one agreement. So do we now want to change those agreements? Do we want to start to be proactive and say we're going to have a separate agreement just for non-solicitation, a separate agreement that addresses confidentiality, and a separate agreement that addresses non-compete, so that if we can't use non-competes moving forward, we only have to eliminate that one agreement rather than all these agreements. So those are things the employer should or companies should be thinking about. They also want to start taking an inventory of what existing non-competes they may have in place. So if you're a large company and your non-competes generally have a range of 3 years, you want to look back 3 years. How many employees that are currently working for your company and employees that have left may have an existing and open non-compete agreement that you're now going to have to rescind and put that employee on notice about. So that could take time. It could take a lot of digging and going through your inventory. So these are proactive things that employers can start to do and start to think about before this rule goes into place or potentially goes into place.
Is there a mechanism for enforcement? Is this a matter of relying on employees to complain or the review audits in place, or how would this be enforced?
So as of right now, it's really up to employers to make sure that they are complying with it. And if an employee feels that it's not being complied with, then yes, it is up to the employee to move forward and lodge a complaint. Of course, if it goes into place, these agreements simply won't be enforceable. So they are nothing but a piece of paper and they would be useless.
So what do you think? Do you think it's going to go live? If so, when? Do you see it being challenged?
I do think it's going to go live. I think the FTC, the government has now put it out there. According to Bloomberg article that I was reading, there were 26,000 comments on the proposed rule, and there's been about 6,000 hours that have already been expended towards reading those comments and working on the rule. And as you can imagine, an obscene amount of money that has gone into it. So I think given all that has been put into it already and the administration's thoughts behind it and how strong they feel about it, I do think it's going to move forward. Apparently, the projected date now is April 2024, which should give them more than enough time to review all these comments and modify the rule as they see fit and put that forward. So I do think we will see it move forward. Whether it will be meaningfully different than it is now, I'm not sure. I definitely think it will be different, but we'll see what that looks like.
How long did it take you to read all 26,000 comments?
No, they're not paying me to do that, unfortunately.
But I imagine there's a theme to them, kind of like a lot of the stuff you've talked about.
Right. There certainly is a theme. It's, the proponents are saying it hinders our ability to move and it hinders wages and all the reasons that they are in support of it. And then the oppositions are putting forth all the concerns that employers have that we originally spoke about. It's threatening trade secrets, it's threatening confidential information. Also now, because it's retroactively applied, what is that impact going to look like? So now you had all these employees for the past 5, 10, 20 years that have had access to all this information because the company was operating under the belief that it was generally protected, not just under your trade secret and IP laws, but under these agreements that they have in place. So now if those agreements are being rescinded and they mean nothing, you have all this exposure. The company has all this exposure that they didn't otherwise have. And it's another consideration, and something that may be litigated if this moves forward, is that particularly for your higher level employees, your C-suite executive employees, often non-competes are bargaining, right? So at the time that they enter into the agreement, there's a negotiation as to what their compensation packages will look like. And part of that is we want you to enter into this non-compete and these restrictive covenants. And the employee, who's pretty savvy, is going to say, what am I getting for this in exchange? So the company is going to offer them higher compensation or better benefits or stock options. So if these non-competes are rescinded and now that C-suite employee leaves, the company is going to potentially want to file a suit against this employee and say, well, we want reimbursement for that extra compensation and those stock options and all the things that we gave you in exchange for something that is no longer in place. So I think there's all this impact that is going to happen that didn't seem to be initially addressed in the rule or in the initial comments or the initial conversations by the FTC, that is now coming to light as it has been thought about more and as all these comments have come forward. So we'll see how that looks and whether that's taken into consideration.
No, I do wonder about the impact on litigation. Anytime there's a change, there's litigation around it. You think this will cause an uptick in litigation over non-compete language?
I think if it moves forward, it definitely will, at least at first, when we're seeing the impact of it unfold. So I think if it moves forward, first, we're going to see challenges to the FTC's authority to even put this rule into place, as we've already seen those issues coming up. And then I think depending on the language, we're going to see challenges to the rule itself. Whether, again, is it constitutional? Does it actually cause unfair competition? There's precedent where we've had non-competes in place for hundreds of years, courts that have enforced it for hundreds of years. So are we going to really overturn that precedent? I think we'll see those challenges. And then as some of the things that we've spoken about, I think we're going to now see a lot of the agreements being litigated. So now that it's been rescinded, what is the impact of that? And are we going to litigate the impact of that? And then moving forward, any other agreements that are in place that are not specifically non-competes, but that are other broad restrictive covenant agreements or NDAs, now that's going to be litigated on both sides. We're going to have employees that are challenging it, trying to say that it is a non-compete agreement and it should not be enforceable, and this is why. And you're going to have employees trying to enforce those or trying to say that they should be in place and this is why, or we need to use them and this is why, because we still need to protect our legitimate business interests. So I do think at first we're going to see an uptick in litigation surrounding anything that's related to a restrictive covenant.
So I guess some of the proactive steps, you mentioned two proactive steps. One, well, you don't have to do anything right now, but if you want to be proactive, it's a good time to review, do an audit perhaps of what your language currently says and how many employees might be affected by it. Was one thing you said to do. And then you gave the suggestion, which I thought was interesting. I was imagining the Jenga game where maybe make the non-compete policy kind of a separate one, and have non-disclosure kind of language and other things, non-solicitation separate, so you could just pull out that one block and instead of having to rewrite everything at the last minute, I guess. Right?
Exactly. Or at least make that a practice now moving forward, because I think some of the challenges, if we try to do that now with existing employees, it's trying to get an employee who's already working here to now sign these new agreements. So it's a little harder, but at least moving forward, okay, any new employees that we have coming in, let's now do it this way instead.
Is there anything else you wanted to say about it? I think you covered it really well.
No, I think it's just a very much to be determined up in the air. So we'll see. The comment period has officially closed on the rule. So we'll see what happens next spring, if that is the true projected date, what the rule will look like at that time, what challenges will come forward at that time. I don't know that it will actually go into effect at that time, because I think there will be challenges to it. And if we're challenging the FTC's authority, the court will likely put an injunction in place and stop the rule from going forward until those challenges are resolved. So I do think we probably have, a year and a half, 2 years before we see anything go into place if it is implemented. Also, we have an election coming up, so that could change things. But if it does move forward, employers will have to address it and deal with it at that time, and we'll see what challenges are made and how we can work around it to still protect the employer and their business and their trade secrets and other confidential information.
Okay. An election. That's the first I'm hearing about that. Andreya DiMarco, thank you very much for speaking with me about this today.
Thank you for having me, Tom.
That concludes this episode of the Emerging Litigation Podcast, a co-production of HB Litigation, Critical Legal Content, VLEX Fastcase, and our friends at Lost G Media. I'm Tom Hagee, your host, which would explain why I'm talking. Please feel free to reach out to me if you have ideas for a future episode, and don't hesitate to share this with clients, colleagues, friends, animals you may have left at home, teenagers you've irresponsibly left unsupervised, and certain classifications of fruits and vegetables. And if you feel so moved, please give us a rating. Those always help. Thank you for listening.